All right, so we're about to have a couple people come on. We're going to be joined with Crystal Salazar, mother from out of Texas, who's going through some issues, asked some questions about how indictments might be able to help a CPS and a family court case. We're also going to be bringing up Heidi again. Heidi was yesterday, so we can continue our conversation because we didn't get to talk about how indictments are going to impact CPS case, how the work that I'm doing is going to benefit those with family court cases. I want to get that clarified because that's really important that you guys understand how these are going to bridge across, how they're going to, how it all applies and it's going to work together. And then we're going to bring up James Bell. James Bell is also a father that's going through family court issues right now. So today is largely going to be talking about family court, guys. It's going to be talking about that. So I'll bring them up in just one moment. Again, you guys, I want the emphasis today to be on how the work that I'm doing is going to help out in these other areas of law. All right. Now, if you guys have never seen my video on "Don't Awaken This Beast," right? It'll be more than you can handle. Guys, go out and watch it. It's I think it's titled "Return the Children or Face the Beast." Right. So all of this has to do with what is the supreme law of the land, guys. I've been hitting this really hard and trying to emphasize this point: is that what is the supreme law of the land? If the supreme law of the land is the Constitution of the United States of America, then that means that no state can abridge those rights, because that would mean that state laws are more powerful than the federal law, and that's not true. To what purpose do we have a constitution? And to what reason did we reduce that constitution to writing if those that are bound to adhere to the obligations are able to exceed them by their discretion? If the states are able to say, oh, we don't want to do what the Constitution so demands, then the Constitution has no force, it has no effect. But we all know that we, the people, in our sovereignty, we created the Constitution, right? The Constitution is our creation. And from that creation came jurisdiction, which is the right for a court to speak the law or to oversee or arbitrate an issue. Absent the Constitution and jurisdiction, no court in the country has any authority to exist because the people did not delegate any other authority outside of the Constitution, the parameters that it demands. No one. So the Constitution is the overarching requirements that every state must follow. You know, this whole discussion about martial law has no bearing in our society, because martial law, what it is it is the suspension of statutory obligations. Go and read the Emergency Powers Act. Okay, Congress said that governors can suspend statutory obligations in emergency conditions. So what the Constitution did, or what the Congress did, United States Congress, is that they said that the governors can suspend the law in certain emergency conditions, because that's all the statutory obligation is the law. Law is a statutory obligation. So if the governors are able to suspend the Constitution, to suspend statutory obligations in emergency conditions, then that would mean that the governors, right? The governors are able to amend the Constitution. That would mean that the executive branch is able to amend the Constitution, and that's not true. In no instance did the people delegate the authority for those to be restrained by the Constitution to be able to disregard the Constitution at their discretion. That was never a delegated authority that people gave. Therefore, martial law has no relevance within our society. No government can suspend the Constitution in any instance, because that would mean that the state laws are more powerful than the federal laws. And to what purpose did we create a Constitution if that's the case? That's not a very robust law that preserves the rights of the people by limiting the powers of government. No, it allows for the government to be unlimited because of what they call an emergency condition, even if they are themselves the ones that created the emergency condition. So, you know, the question is there are a couple of different types of constitutional rights. The most important constitutional right of all is known as a fundamental constitutional right. It's a fundamental constitutional right. And a fundamental constitutional right is one that's so important and imperative to the fabric of society that we called it out within the Bill of Rights, the first 10 amendments. if it's enumerated within the first 10 amendments of the Bill of Rights, that is known as a fundamental constitutional right. And a fundamental constitutional right can never, ever, ever be taken because those are given by God, right? Those are the God-given rights. Now, we're gonna take a step back and we're gonna say, okay, judges can take a fundamental right, right? They can take away your liberty because that is a fundamental right called out, right? They can take your liberty, but taking of your liberty comes with certain prohibitory attachments to it. And that's what the Fifth Amendment is the Fifth Amendment is prohibitory amendments or prohibitory provisions. So what it does is the Fifth Amendment, all of the provisions within the Fifth Amendment, what it does is it creates an act of deprivation that government could commit, but it comes with a prohibitory requirement, a prohibitory element. Okay, so no property shall be taken for public use without just compensation. That doesn't say that you can have your property and it's yours. That doesn't say government can take your property, it's theirs. What that says is that your property can be taken for public use, but it requires a prohibitory element of just compensation. Absent just compensation, the act of deprivation by government is unconstitutional on its face. Okay? They've exceeded the power or authority statutorily conferred upon them by the act of deprivation because they did not have the prohibitory element. They must justly compensate you if they intend to take your property. Okay, so another provision is the Fifth Amendment's grand jury indictment issue, right? No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That doesn't say that you have the right to be free. It doesn't say that the government has the right to arrest you. It says that the act of deprivation can occur and you can be held for a crime, a felony crime, but it comes with a prohibitory element being there must be an indictment by a grand jury. Absent the indictment by a grand jury, that act of deprivation committed by government is unconstitutional, giving rise to injunctive relief. It's a very, very simple situation, right? Government right now today has more than 700,000 people currently imprisoned here in America on direct facial constitutional violations because the states did not have an indictment by grand jury at all in the adjudication of their crime because the states feel as though they can substitute their own alternative legislation for what the Constitution of the United States of America fundamentally preserves and provides. You have the right to indict by grand jury before being arrested and held over for an infamous crime. Therefore, in the state of Washington, when the state of Washington says, we're not going to do it, no grand jury shall be joined or summoned in any county, Article 1, Section 26, that means that the act of deprivation, the arrest itself, being held over for an offense without an indictment by grand jury, that is unconstitutional and it is facially unconstitutional. It is a direct, willful defiance to the very procedures and processes codified in the Constitution of the United States committed by what is now criminal. A prosecuting attorney is now a criminal, a felon, right? That judge is now a criminal, a felon. Every single time that they do it, every single time they hold someone over without ensuring that they follow the rules that are constitutionally codified as their obligation. So I want to bridge from that issue right there into CPS and family court cases. Because you guys, they have a direct relevance, right? And there's a specific reason why I'm using indictment by grand jury. And I hope that between Crystal, Heidi, and James, we can leave this discussion right now with an understanding as to why what I'm doing with indictments by a grand jury and prisoners is going to directly impact your case on behalf of your family and the preservation of that family as fundamentally guaranteed by the Constitution of the United States, incorporated by the United States Supreme Court in 1984 under the Roberts versus United States case, okay? So let me bring up these other people. 1 second, guys. James, go ahead and ask to join as well, brother. Okay. All right. We'll bring up a couple people, but we're gonna be. I need to make sure that I know who they are. Okay, guys. All right. Heidi, thanks for joining me again here.
Yeah, thanks for having me.
Yeah, so I was just talking about fundamental rights, and but yeah. So when it comes to a fundamental right, you guys, if government can take it, if it can be taken, then there are 4 levels of a judicial test. Okay, now a judicial test is the judge must test their discretionary authority, right? There's certain things that they have to do in order to take action, a judicial act. Okay, so there's 4 levels of judicial test. The highest judicial test is known as strict scrutiny. Okay, that requires the compelling state interest test, and any fundamental right, any right that's called out within the Bill of Rights, must pass strict scrutiny, and the compelling state interest test must be used. Now, with the compelling state interest test, what happens is that the state has to go out and they have to prove that there's nothing else that they can do except for deprive of this fundamental right. Because we don't want fundamental rights being taken. So your freedom to speak, right? Your freedom of religion, your right of conscience, your freedom of press, the right to children. These are all things that are fundamental, all within the First Amendment. They're all freedoms. So in order to take away your freedom to speak, what they have to do is they have to prove that there's nothing else that they can do but for deprive you of that fundamental right. Because you're going to be permitted to speak until the day you die. The only thing I can do is gag order you, ignore you, put you into a cell where you can't be heard anymore, such as they are doing today, right? In fact, we have a major freedom of speech issue in the plea bargain situation, because every single witness has the right to testify freely, fully, and truthfully to any matter pending before the court. Refer to the rules of civil procedure and evidentiary procedure. So every witness has the right to testify freely, fully, and truthfully to any matter pending before the court. If you were to go out and say to their witness, the accuser, and say, oh, well, I'm going to shoot you if you come and testify, you're going to go to prison for doing that. Because what you're doing is you're preventing that witness from being able to testify freely, fully, and truthfully to the matter pending before the court. And that is a crime called witness intimidation and tampering, right? It's a substantive issue, something I deal with. It's a substantive law issue. You cannot have something of substance occur that's going to break down and defeat the validity or the integrity of the judicial proceeding. And that's one of those things that does it. Any witness that's being prevented from being able to present their evidence to the proceeding fully, truthfully, and freely, fully, and truthfully to the matter pending before the court would be a crime. So you can't go up to their witness and say, okay, I'm going to shoot you if you come testify. Therefore, that prosecutor cannot come to you and say, well, I'm going to send you to prison for 20 years if you come and testify. Because what they're doing is they are preventing you, the accused, from being able to testify freely, fully, truthfully to the matter pending before the court. And remember, witness tampering intimidation is any direct or indirect intimidation, so it doesn't have to come from the prosecutor. It can come from your defense attorney, from the prosecutor, because that would still be witness tampering intimidation and so on. So we're seeing this also in family courts prolifically, right? Because the judge is taking one side of the case, be it CPS in the state, or one spouse, for whatever reason, they determine that they're going to go with this person, not the other person. And then they're suppressing the other side from being able to tell, their side of the story. We're seeing it in a lot of cases right now. Now, there was a case from the United States Supreme Court back in 2010. It was, the assenting opinion was written by Justice Kennedy. And what Justice Kennedy said is he said that with regard to matters of speech, government must be content neutral, meaning that they can neither favor nor disfavor one side or another. Therefore, government cannot hinder or obstruct free speech in order to control the narrative. That would be a First Amendment violation of the most basic sort. Most basic sort. So if government decides, oh, I'm going to side with this, I'm going to let this spouse say all the things that they want to say, right? And I'm going to side with them every time. But over here, I'm going to deny all the motions. I'm going to say, oh no, you don't get to testify. Oh no, this is not a recorded proceeding, or just outright, we're going to arrest you and put you into jail so that you can't even come to these proceedings anymore, and we'll proceed without you, right? Either way, that's government taking a side so that they can control the narrative, which is a First Amendment violation of the most basic sort. So when it comes to a fundamental right, the only way that they can take it would be through the highest judicial test, called the compelling state interest test. And that means that they must show that there's nothing else that they can do but for this act of deprivation. But when I say show, that means that the state must show, meaning that the state can't be the one to do the assessment. right? Because a federal constitutional right cannot be infringed by state laws because state laws are inferior to the federal laws. Therefore, no state court can deprive you of a federal constitutional right. Thus, in all cases which a state is a party, the Supreme Court has original jurisdiction. Because the federal courts are the only ones that can remove a federal right, because if the states could remove a federal right, then that would mean the state laws are superior to the federal laws, and that's not the case. But that's what we're arbitrating. That's what we're litigating. That's the heart of the case, and this affects so much more than just simply indictments by a grand jury. But there's a very specific reason why I use that. But again, going back to, so the highest judicial test is a compelling state interest test. And the states cannot perform the compelling state interest test. They must go to another court, which means, according to Article 3, in all cases in which a state is a party, the Supreme Court has original jurisdiction. Therefore, the federal court is the only one that can remove a federal right, because states don't have the authority to violate something that's outside of their limited statutory governing limits. Okay. Now, the lowest judicial test of the four is what's known as a discretionary test, meaning that the judge can use his discretion to remove that fundamental right. Never, ever, ever can a judge use the discretionary test to remove a federal a fundamental right. Never. Can never do that. Guys, look it up. Black's Law. Very, very simple. You can never use the discretionary test to remove a fundamental right. Okay? So when the Supreme Court of the United States came out in 1984 under the case Roberts versus United States, and they said that you have the right to an intimate association with your child, meaning that you have the right to have an intimate familial relationship with your child, and your child has the right to have an intimate familial relationship with you without governmental interference, then that means that that is a fundamental right protected under the First Amendment, because they specifically said First Amendment. It is fundamental, bound to be fundamental under the First Amendment. Then that means that even though it's not written in the Constitution, it's found to be fundamental. Supreme Court incorporated. They said, oh, it exists. It's not written, but it exists. You have the right to have an intimate familial relationship with your child without governmental interference. And so, because it's fundamental, then any judge that uses their discretion in that courtroom to say, I can remove this child from you by my discretion, would be clearly abusing their discretionary authority with which they're invested in law. Because you may not use your discretion with regard to a fundamental constitutional right. There are four judicial tests. The highest is this compelling state interest test. You got to go to a federal court to do that. The lowest is discretionary. The judge has the ability to use his discretion to take away this right. But according to the Circuit Court Handbook, we're going to go back to what we talked about yesterday, the Circuit Court Handbook. If you guys want to know what an abuse of discretion is, it is called out specifically in the Circuit Court Handbook, United States Circuit Court Handbook. And what it says that there is a two-part test to determine abuse of discretion. Two-part test. That the Circuit Court will apply a two-part test. The first test is, did the court rendering the decision, did they apply the incorrect test? Yes, they did, because that judge used his discretion abusively to remove something that he has no authority to remove because it's fundamental, incorporated by the Supreme Court. So when they do abuse their discretion by applying the incorrect test, that is an abuse of discretion. Therefore, an abuse of discretion has occurred, right? And anytime that you have an abuse of discretion, according to Blackstone, 3 crimes result from that automatically. Per se crimes, meaning that we don't have to show that they intended to do it. We don't have to show that they willfully did it. All we got to show is that they had an obligation, they didn't fulfill that obligation, and they're guilty because they've already implicitly invited punishment in the form of perjury should they fail to fulfill the promise they made. That's the effect of the oath. So 3 crimes automatically come that are per se with regard to any person that abuses any discretionary authority with which they are invested in law. Blackstone 2009. The first crime is extortion, because they are compelling a result through illegal means. They're abusing their discretion to bring about a judicial decision. They're abusing their discretion in order to compel a result through illegal means, right? So first crime is extortion. Second crime is perjury, because they made a promise, they didn't fulfill the promise, and they've already implicitly invited punishment should they fail to fulfill that promise. So now we've also got the crime of perjury that's automatic. And the third crime is oppression, which is what tyranny is. Oppression is the unequal application of laws by a person in position of authority. So that judge earlier that day said, "Oh, I'm going to let this husband have unrestricted, uninterfered access to their child, but this mother over here, no. I'm going to take away her rights. I'm going to put in no contact order, prevent her from being able to even speak with her kids, because I'm going to apply the law unequally amongst like members of society." And the judge may not do that, because the law must apply equally to every single person. If you, judge, are going to give one person one right, then you don't have the authority to apply that law unequally on a different person, because you're in a position of neutrality, right? And neutrality means that you may not apply the law unequally amongst like members of society. Otherwise, you're a fucking tyrant and you're committing oppression. Okay, and that's an automatic, because you're applying the laws unequally amongst like members of society. We see that also with this indictment issue. So with the indictment issue, if the state of Oregon requires an indictment before you're held over, and you have that right, then why is it that Washington State doesn't have an indictment by a grand jury? Why is it that a citizen of the United States can be residing in Oregon and then cross a river a quarter mile away, and suddenly they don't get, even though they're still a United States citizen residing within that particular state? That is oppression. It's a violation of the 14th Amendment. No state shall create or enforce any laws that do not provide equal protection of the laws. That creates the egalitarianism structure that we have here in America with our system of government. So we have a pretty big deal. But now going to the family court issue, okay? So what they've done to all of you by removing your children after it was determined that your relationship with your child is fundamentally protected by the First Amendment of the United States Constitution, and yet they're still going to do it. Here's what they've done, okay? So remember, on the indictment issue, it was when the state created a law and then substituted it for the guarantees of the Constitution, and then directed all their agents to go out and enforce that inferior state law in violation of the Constitution of the United States of America, they committed a crime, deprivation of rights under code of law. And when they brought it to a judge and they asked the judge to hold this person over, that judge had to do the responsibility to make sure that the power he does exercises is consistent with his authority, right? When he chooses to rely upon the judge's abuse of power, who brought the incorrect charge to instrument by relying upon an inferior state law that deprives a person right guaranteed by the Constitution, that judge is also depriving of rights under color of law. He's now established a conspiracy to deprive of rights, Title 18241, by and between himself and the prosecutor. And now we have a much, much bigger situation, because when the officer then goes out relying upon the judge's abuse of power and performs an arrest without having the proper documentation or authority to do it, now we have the crime of kidnapping, and now we have a capital offense, because anytime you have kidnapping that occurs in conjunction with deprivation of rights, it's always, as prescribed by law, punishable by death. So that makes this a very, very significant situation that's happening prolifically, but that's the indictment issue. Now, the same thing can be said, because here's the thing. The Supreme Court of the United States said in 1984, Roberts versus United States, you have the right to have an intimate relationship with your child without governmental interference. So when a state creates a law that says that we can interfere with your relationship with your child, that would clearly be unconstitutional, because it would be violating the fundamental rights found to exist, incorporated by the United States Supreme Court, by Roberts versus United States, that the states were not able to abridge, because no state can create a law that violates or abridges a fundamental constitutional right. Refer to Amendment 14. No state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens, and the privileges and immunities of United States citizens are at a minimum what is enumerated within the Bill of Rights. Timms versus Indiana, 2019. Unanimous decision. Same Supreme Court justice we're dealing with today. So when the state did create a law that abridges the fundamental rights of the people, right, and then they directed their agents to go out and enforce it, being CPS, because CPS is an agent of the state. They're enforcing the laws of the state. They would have no authority to be able to take your child, but for their authority granted by the state. So they're out there enforcing the laws of the state. They're an agent of the state. They're part of the executive branch. I don't care what any one of these governors say. The CPS works for you, right? They would have no authority to do that, but for your laws, therefore they are your agent. So when CPS goes out, right, and relies upon the inferior state statute that tells them we can take a child, right? We can take a child from this family. We can interfere with the familial unit, right? Interfere with the right of intimate association. We can take this child by our discretion. But once again, discretion may not be used with regard to a fundamental right. That's the incorrect test. You cannot use discretion with regard to a constitutional obligation. because that would mean that you're using your discretion abusively to break the Constitution. You can't do that, okay? But the problem is that intimate association was bound to exist. It was incorporated by the court. It's not enumerated. And there's a big difference between an enumerated constitutional right and an unenumerated right in how you deal with the litigation, okay? It would be very difficult for us to get CPS in the CPS issue on an unenumerated right, because we would bring it to the court and say, oh, in 1984 you said that this existed, and then that would give them the ability to say, oh, well, we found that it no longer exists because it's not written. You must have an enumerated constitutional right in order to effectively challenge the deprivation of rights, okay? It has to be written. And the Supreme Court even said that in 2019 in the case Timms versus Indiana, when they said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. So if it's in the Constitution's text, if it's enumerated, that is at a minimum what every single person across the whole country is guaranteed without a doubt, can't be obstructed. And so now we have an issue where we have a specific enumerated right known as an indictment by a grand jury, an obligation that exists, and we have a number of states that are failing to fulfill it. Now we have something that we can attach to, latch onto, bring this case to the court. But the argument isn't about indictments, right? But we have to use an enumerated constitutional right in order to get us in that court to be heard, because it must be enumerated for it to be at a minimum. Now when we get there, the argument or the issue is there's two parts of this issue. One is, what is the role of states within our system of government, right? Are they sovereign? Because if they are sovereign, then that means that they can create laws that abridge the Constitution of the United States. But unfortunately, if they are sovereign, that means we don't live in a union. That means we live in a confederacy, right? Because a confederacy is two or more sovereign states with a loose decentralized government structure. We switched back into a confederacy, and unfortunately for that particular path, the Constitution says in Article 1, Section 10, no state shall create a confederacy, or no state shall form a confederacy. So if we are living in confederacy, then we're already barred from that within the Constitution, so we should probably have that discussion with the people of the United States anyway. But if we are living in a union like everybody believes, then that means that it's two or more non-sovereign states with a centralized governing structure, and that means that no state can create a law that abridges the guarantees of the Constitution, because the states gave up their sovereignty to join the Union to subject themselves to the supremacy of the Constitution of the United States of America. It doesn't matter which Constitution you say, which Constitution. That's a silly question, because there is only one Constitution. The second Constitution that everybody talks about was entered into without knowledge of the people. So if you bridge an obligation of a contract to formulate a new contract, the second contract is void. I'm not going to talk about a second one because the first Constitution, right, what the people negotiated, offer consideration, acceptance of the people, the contract that exists is the Constitution of the United States of America, the first one. Any other one was created without the people's consent, right? Therefore, when they breach the terms of the first contract to enter into the second contract is void, null, it doesn't exist. You can never breach the terms of the contract to formulate a new contract without making both contracts void. So we don't go under the assumption that there's a second Constitution or a third or any other one, because all of those would be formed out of a breach of the terms of their contract, the Constitution of the United States of America, the first one. So we're not going with those, all right? Well, so we'll come back to that. Heidi's going to ask some questions about Trump. We'll come back to the fact, though. But so where we're at right now is that we need to use an enumerated constitutional right, one that's written within the Bill of Rights. We need to use an enumerated right so we can get in the court to be heard, because at a minimum, what is enumerated in the Bill of Rights is guaranteed to every person. So why is it that there's 700,000 people currently imprisoned here in America on direct facial constitutional violations that never received an indictment by a grand jury? That's big enough to get this court to get this case heard. But then we also have 2.7 million that are sitting in prison that were never present to confront the hearsay accusations against them, right, in a grand jury proceeding. And they were denied the right to be there by the very individual that the proceeding is designed to protect them from, the prosecutor, right? The grand jury is there to protect the accused from hasty or malicious charges by an overzealous prosecutor, and yet the prosecutor is denying the accused the right to be present to benefit from the proceeding that's there for their protection from the prosecutor. It's insane. All of those people are also sitting there illegally and unconstitutionally because what happened there was that prosecutor committed obstruction of justice the moment that they denied the accused the right to be present to benefit from the very proceeding that exists for the protection of that defendant. Right? And now we have a much bigger issue. So now we have something worth litigating. But again, there's two issues. One is, what is the role of the states within our system of government? We are going to destroy sovereign immunity. Sovereign immunity does not exist. It's bullshit. It doesn't exist, okay? It's bullshit. And we're going to destroy it. So sovereign immunity, we can destroy because the states cannot be sovereign because that would mean that they're a confederacy. And if they're a confederacy, then that's barred against by Article 1, Section 10. And then we get into ex post factos where even if you do become sovereign now, you weren't sovereign then. Therefore, until it's changed by the Constitution, you guys, you got to do what the Constitution says, okay? So we really win either way because even if they do come back and say, oh yeah, we're sovereign, we formed a confederacy, well, the confederacy barred under Article 1, Section 10 because you states cannot form a confederacy. It's already there, okay? So the first one we're dealing with was sovereignty. And there's a direct path to sovereignty, to eliminate sovereign immunity because sovereign immunity was a decision that was created by the Supreme Court of the United States in 1890, a case called Hans versus Louisiana, where the Supreme Court of the United States came out and said, yes, we don't read the 11th Amendment literally, we read it figuratively, and we believe that it interprets, or its intended purpose was to grant the state sovereignty. Thus, sovereign immunity was born in 1890 under Hans versus Louisiana. But unfortunately for the Supreme Court of the United States, you don't have the authority to amend the Constitution of the United States and alter your obligations because that must be done by an authentic act of people. Nowhere in the 11th Amendment does it say that the states are sovereign. It only says that a citizen in one state cannot sue a different state. Therefore, you're barred from being able to sue a separate state. But it says nothing at all about suing your own state. And even Justice Souter stated in 1996 in the case Seminole Tribe of Florida versus Florida, Justice Souter said there appears to be two versions of the 11th Amendment that exist. One created by the people in 1795, the other conceived by this court almost a century later, referring to Hans versus Louisiana from 1890. So, we've got a path to be able to deal with sovereignty. The Supreme Court of the United States has no authority to be able to amend the Constitution of the United States, and yet that's exactly what they did in 1890. They created an immunity for them in order to protect them from being able to be sued in federal court so that they can pursue this slavery institution such as they have for 243 years under these judicial rulings that they've erroneously called law. So that's issue number one, right? What is the role of the states within our system of government, right? Destroy immunity, right, with that. The second thing is can a state be both accuser and judge in the same proceeding? And the answer is no. Article 3 says it can. In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. We have the Constitution, Article 3, that says if a state is a party, can't be the judge. We have James Madison, the father of the Constitution, writing in the Federalist Number 10, saying that a body of men cannot be both accuser and judge at the same time. Got that, right? The father of the Constitution, his own words in the Federalist Number 10. We have another founding father, Alexander Hamilton, Federalist Number 80, that says that in all disputes between a citizen and a state, the federal judicial authority must extend. Okay, so now we say if there's a dispute between a state and a citizen in that state, the federal judicial authority must extend. Federal judges must be the judge, right? Said that right there. Now, he also said in the same Federalist Papers, he said that no state tribunal can be presumed to be neutral and biased when it speaks for itself. Right? Therefore, no man ought to be judged in his own case or in a case with which he has the least bit bias or interest. So now we have Alexander Hamilton making two statements in the Federalist Number 80. We have James Madison making a statement in the Federalist Number 10. We have the words of the Constitution. And then we have John Jay and his words in the Federalist in Martin versus Hunter's Lassie from 1811, where he said that the Constitution is presumed that state interests, state prejudices, state biases might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants jurisdiction to the Supreme Court. It's the case and not the court, because the Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. If the state is a party in a cause through any one of its agents, that state and same body of men may not be the judge in the case, and as a result, that judge has an obligation to recuse himself, constitutionally codified and upheld by judicial code, because Title 28, subsection 455 says, it says that that a judge has an automatic, mandatory, self-executing, non-waivable duty to recuse himself if he is an officer of either party. And these are judicial officers of the state. The state just happens to be a party, the movement, the petitioner, and as a result, that judge has an obligation under Title 28, subsection 455, to recuse himself. It is mandatory, it is non-waivable, it is self-executing, and it's an obligation to do so. Failure to do so means that that judge is acting without jurisdiction, and according to Hill versus Weeks, United States Supreme Court, that judge is now committing the crime of treason, warring against the Constitution of the United States, and now we have a pretty significant issue. Judges may not ever take action in a case in which they have an automatic recusal, because if they do, they are now committing the crime of treason, already litigated, Hill versus Weeks, United States Supreme Court. So let's bring Heidi up here. I got a couple other people, we'll bring them up. Heidi, let's go.
Yeah, I had a couple questions. But first I just want to say, like, the Constitution, I think, is actually banned in family court. It's not even, I mean, it's not even referenced ever. And fundamental rights are being taken literally like hourly. And I think because there's no oversight and there's no jury and there's no nobody watching, it's just, you know, the judge, he's the juror and everything, that it's a record of court. It's not a court of record. And that's why they're doing, you know, whatever they want. And I know you talk a lot about like abuse of discretion, and I don't think these judges, I think these are calculated, erroneous abuse of the law. I don't think it's just, you know, misimplied, that this is all calculated, which makes it 100% criminal. And so that kind of leads me to my question, because they are per se crimes, are we to go right, you know, to the FBI? And I know that Senator Grassley has been scrutinizing the DOJ and FBI, but what are your thoughts on, you know, Kash Patel and Dan Bongino running the FBI? Or I guess, you know, the whole administration under Trump, is it safe to, you know, to go to where we're supposed to, because it.
Yeah. So let me go back to what I say to everybody, that we you got to look at words and actions. If you want to know if someone's being truthful, you got to look at words and actions. Words and actions. Because if your words and actions don't align, then you're a liar. So you got to look at what they say versus what they do, and that's going to tell you, you know, if they're being truthful or not. That's the primary indication. So let's take, for instance, Chevron, right? The ruling that was made by the Supreme Court on June 28th of last year, where they said that executive branch, you don't get to create policy because you think that the law isn't clear, it's ambiguous. You don't get to write policy and then go out and enforce that policy against people in the United States as though it's law, because all the law must be made by the legislative branch. So basically what the Supreme Court said in Chevron was executive branch, you don't have any power to legislate. All legislative power is vested in Congress of the United States according to Clause 1, Article 1 of the Constitution. Therefore, you may not write policy and go out and enforce it. Right? So that's basically what they said. Now let me ask you, was Chevron effective in correcting the behavior of law enforcement out here? James, do you still see these officers out enforcing policy? They didn't change anything.
Well, what I think is going on is, can you hear me okay?
I can, James.
So what my opinion is, and just to give a little background, I'm an Army Staff Sergeant retired. and I was in the Kunar Province, Afghanistan, and 2009 and 10. So I'm looking at this as a father. I'm looking at this from my military background and from just as an American citizen who has had his parental rights taken. And, I fought and bled for my country. And then I come home to have my rights taken from me. But what I began doing, and this goes back to 2015, is I started investigating into what is actually going on. And what the courts do, it is like she was saying, it's a more intentional than just them having their way. This is something that aligns with the globalist agenda and the New World Order. It's not nothing new. People have seen this, play out in these courts, but in the last 20, 30 years, they've definitely gotten out of control. But now it goes back to, 1833, Hurtados versus California, when they stopped using indictments by grand jury and using information. So then when the family structure came into this was when they started attacking the mother or the father that is not the one that is the criminal, but the one, or the abuser, but the one that is the stable, the more stable, and not necessarily more money, but money is a big factor in their decision, which they say is the best interest of the child, but what that really is, the best interest of the state, is what they're talking about. So when you break it all down and looking at this from a military view, it's definitely, it's treasonous when a judge acts out of their jurisdiction. First off, they know the law. The attorneys knows the law. They refuse to do anything constitutional. I mean, that's, what else do you want to call it but treason?
Yeah.
And so treason, deniability.
Yeah. So treason. There are a few requirements of treason. Interestingly, in the Constitution, one requirement is it must be done in open court, right? And these guys are doing it in open court. Like they're meeting the requirement for treason directly out of the Constitution, because every single time that an officer presents an affidavit by information or requesting violating the Constitution, that is being done in open court, officer. Right? That's being done in open court, prosecutor and judge. You guys have some very, very bad shit coming your way, and we really would like you to wake up and realize this, because this is a very dangerous situation for 40,000 judges across America that are traitors to the United States of America, committing it in open court as required by the Constitution of the United States of America, right? And we know the punishment for treason. But you don't get a finding of facts, public official. You don't get it, right? If you have an obligation and you promise to fulfill that obligation and you breach that obligation, it's already been litigated that it's a per se crime. And I'm going to tell you that people are justified in whatever action they take to address the criminals and traitors that are destroying our country. We are justified in it. God has even justified, such acts. We have an absolute right to defend freedom, because we all have the absolute duty to defend the freedom. We can't claim to be free unless we accept our obligation of defending that freedom. And if we breach our obligation defending the freedom, then by the breach of obligation to defend it, we will have ceded our right to be free. And that's where we're at, is that no. We have the right to be free. Therefore, we have an obligation to defend that freedom. And if we don't defend it, then but these traitors, right? That is absolutely what they are.
I'd like to make some pretty important points, though. I want that everybody that is hearing this, that are the parents of children have been taken, or maybe they're just going through the process. you got to understand that the court are enabling the abuser, the narcissist.
Yeah.
So every narcissist has an enabler.
Yeah.
It's the judges, the attorneys, the CFI, the CPS, all of the above. And what we need to do is to come together as a nation, because we have the authority on a federal level as American citizens to come together. We do the affidavits one by one all across America, whatever we have to do to save our kids. But it's not only treason. Treason is a very serious thing, but what they're doing with the family courts is they're purposely breaking down the familial unit, which is covered by John Roberts versus USA, 1984. So they're going in direct, violation of that. And so then you look at it and say, what is their purpose? What is their intent? Why are they doing this? Well, the intent is to break down the familial unit. And then they're going to have more criminals in the system to enslave. Yeah. And then what's going to happen next is they can bring in people from other countries and replace the American family with people that have any kind of obligation or allegiance to a constitution of the United States. And this is how they break down the American way of life and our country as a whole. And it's an attack. It's an attack against every one of us as American citizens, as families. But this is what's really where they messed up, was they came against me with this in the criminal court for nothing. But the thing is, when they acted against this, against my kids, then they violated all of my kids' rights.
Yeah.
My rights was violated. That's one thing. But when they violated my daughter's rights, okay, we'll see where this goes.
Yeah. So one of the reasons why I wanted to bring you up, James,
under God to protect these kids, like you're saying, James, and it's
our duty and responsibility.
Right, and it's not just my kid, and it's not just James's kid. It's all these children, and we're being at this point complacent because we know what the hell's going on, and it just we need to come together, like James said, and a lot of people that aren't part of this don't understand what Mr. Downey is talking about, but it is all in one, and it's gonna affect, it may not be in your house right now, but it's creeping at your door or your neighbor's door, and it affects good people. And James, thank you for your service, by the way.
Yeah, thank you. It's an honor and privilege.
I'm just gonna stay
I mean,
here.
I'll be honest with you. Everything that
Brought me on a podcast
that I
right
see
now.
has absolutely
Talking about family court.
led us to
please
breaking down.
please put your phone on mute, please. Put your phone on mute. Thank you, brother.
It's the breaking down of the familial unit, and what it is they don't want anybody to have any kind of knowledge of this Constitution. That's why it's so important that the knowledge that Tanawah has and has freely given everybody is something we all need to know in our hearts, because Jesus said, you shall know the truth, and the truth shall set you free. And it's going to set us free, it's going to set our kids free, and it's going to set everybody's kids free.
Yeah.
And there's been a renewing of God's Spirit that is poured out on us, and we have that information that is flowing across our country. And it's a great awakening. And the parents, it doesn't matter whether you're fighting a battle with a narcissist or not. You're never going to win that battle in a corrupt family court. So we need to not so much even target the parents of our kids and blame them so much, but we need to blame the ones that are enabling them, the ones that are doing this on a daily basis. And when they're called out on it, they use plausible deniability, which they're in full knowledge of their agenda, and their agenda is to break down the familiar unit. And it's, by definition, in Black's Law. I mean, honestly, mental and physical abuse like this against the familiar unit, the American way of life, is genocide. And that's what it is, and that's what they're doing.
Yeah.
So we're getting into international crimes.
Yeah. So let's. Yesterday I talked about the spirit, right, and judging spirits, right, and being able to know, what spirit is against you, because if you understand what I said yesterday, where I know what side I'm fighting on, because I know the things I'm demanding. All that I'm saying to do is consistent with what God demands. Therefore, I know what side I'm on. I know what side I'm fighting for. And if I know what side I'm fighting for, then I know that people that fight against me are not on the same side as me. It's a very, very simple concept. I know what side I'm on because I know who it is I'm fighting for, because I know what my heart represents and what I'm asking for is consistent with what God demands. So understanding that if I'm fighting for God and that court is fighting against me and everything that they're advocating for is the opposite of what God demands, then we know what side they're on. And so, like I said yesterday, once you understand the spirit of deception, once you understand the lies that they've been told, then you know that a liar is going to feel most comfortable with another liar, right? My heart tells me that those judges are liars or criminals. I don't like them because my heart's telling me that they're liars or criminals. I know that because my spirit's telling me that, right? But their spirit, likewise, is going to tell them, don't work with me, because they think I'm a liar. Because a narcissist can't self-reflect. They can't understand that they could possibly be wrong, right? So these judges, these attorneys, they're all liars, right? They're all filled with the spirit of deception. So obviously they're not going to like me because I got a different spirit. They're not going to side with me. They're not, because they can't self-reflect and figure it out for themselves. So one of the examples is that we had these affidavits. These affidavits, I'm not requiring a notary signature on them, right? I'm not requiring a notary, nor am I requiring 3 witnesses to sign. Guys, that's for an intended purpose. I did that for a reason. That's not because they aren't supposed to be notarized. That's because if you want to defeat a narcissist, what you must do is you must reflect what they do. You must mirror them. Guys, if you want to defeat a narcissist, the first step is you must do what they do. Because how many officers notarize their affidavits when they deliver them to the prosecutor to prepare an information? 0. Not 1. They don't notarize theirs. So a narcissist can't self-reflect. They can't possibly presume that they're doing anything wrong because they're perfect, right? They got this image of perfection. And so in doing so, if I do the same thing that they do, then if they accuse me of doing it wrong, that's simply something that's them. That's something affecting them, just like any other liar. A liar accuses you of something that an accusation is an admission. So if they accuse me of doing it wrong, it's because they know that they're doing it wrong. It bothers them. We have to attack them in the way that you would normally attack a spirit of a narcissist, right? We're going to do the same thing. That's why I don't require an affidavit, because they don't notarize theirs. So if their affidavits are all wrong, the only way I can make them self-reflect on their criminality is by doing the same thing as them and letting them get pissed off and annoyed by it and accuse me of an admission that they're actually doing themselves. So,
exactly. So that, going to that point that you're making right there, I don't think I've ever seen anything signed by a judge or by a prosecutor, anybody. I don't think it's ever been signed, to where it's notarized. I haven't even seen a judge's signature.
Yeah.
But
so
back to what they're doing.
So I wanted to say, guys, so one of the next things that we're doing here, over the last few days, I've been here in Oklahoma City, and we've now served, so there was a judgment that was entered into. It was entered into on December 2nd of 2024 at the United States District Court of Western District of Oklahoma. All right, this was on behalf of the Ricks family. The Ricks family brought it. It was a common law jury trial, but nonetheless it was a jury trial. The jury took months to deliberate. They reviewed it. It was a fully impaneled jury. It was signed by the clerk of court. It has a case. You guys can look it up. It's out on Pacer. The decision was made by the jury that Miss Ricks must have her family brought back to her. Her family must be returned to her. Right? There's number one. Number two, the state of Oklahoma is responsible now for a punitive damages of $10 billion. $10 billion. That's 10 zeros. $10 billion. Now the state of Oklahoma is refusing to acknowledge it, despite the fact that it's done. It's signed. It's entered into. It was the United States District Court of Western Oklahoma. It's done. But the state of Oklahoma is refusing to acknowledge it. So we're now serving, and we've gone through, we've served the governor, we've served the treasurer, we've served the secretary of state, we've served the mayors of Stillwater, we've served the mayor of El Reno, we served all the sheriffs, all the judges, we served everyone over the last few days. We're there, right? But we have this judgment by a jury trial, right, that's signed by the clerk of court. And there's a couple things that we need to do still to push this up here. But we have a $10 billion judgment against the first state here. And the state's going to have a difficult time paying for that, Mr. Stitt. You might have to sell one of your gateways off, right? But nonetheless, so this is enough money to bankrupt this first state. And this is one case out of hundreds of thousands that could be an option here. It's a huge damages by one single jury trial. One single instance of where CPS stole children from families, and we got a judgment that exists, jury trial, we've got the order, and now we've served the demand letters yesterday. We have another tack that we're doing today that we're not going to discuss with anybody because we want it to be a little bit of an ambush. But we have what we need right now to take down the first state. We just have to get them to acknowledge it, which is, the video that I just posted yesterday, you guys, here in Oklahoma. This is enough that we are able to take down the first state. And if this works, we have the ability to create templates of this exact same thing in multiple states. And how many states are we going to be able to get through and bankrupt before they're going to be brought to their knees and say, enough? What do we got to do to fix this? Right? $10 billion is enough to do that. Mm-hmm. So, she'll never see the $10 billion, right? But that's not what she's doing it for, right? Obviously, she's doing it because she wants her kids and she wants the restoration. We got that, but it is enough money that with the judgment done by the jury trial, signed by the jury foreman, signed by the clerk of court. It's a judgment that's valid. It's valid. And once we take down the first one, we're going to see them start falling immediately after that. And once they start falling, it's not going to take us long before they're going to be begging for me to get back to D.C. and to present this argument because these states are not going to be able to survive any longer. All right? So we have the first judgment, $10 billion. We're not going to get that money, but that is absolutely enough that Mr. Stitt, I want to step up and do something about it because today's a whole nother day of action we're gonna take. So, but that being said, you guys, one of the things that we said is that I've served all the top. I built the top ready to collapse, but we don't have the bottom built yet, right? We haven't served yet the county judges or the county prosecutors. I don't think that that's necessary because we did serve their boss. But we want to bring some more noise to this issue. And I've been saying that we're going to do this here for a little while. But we now have some videos of me going out to the counties and serving county sheriffs and county judges. We have that video, which is good instruction video for all of you. So we're going to work on the next couple of days. And certainly in the next week, hopefully by the end of next week, we will have the steps that you need to serve for both indictment violations and familial court violations. I have the affidavit for the family court. It's just that we have a couple of different versions that we have to work through because I need to get the most people in the same procedural situation. So we're going to have the indictment affidavits, and you guys, you're still returning them to me. Don't just go and take this and serve this on your county judge. You still got to get them back to me. But we're just going to create more noise because guys, they're scared of this shit right now. They're scared of it. We know that they're scared of it because we can see Chevron, because we can see the DOJ Grassley memo, right? Those are direct response to the work I'm doing, right? We're seeing a manipulation of government at the highest levels, fighting amongst each other simply because no one wants to take accountability for this great big freaking issue of a whole bunch of people who have had their fundamental rights taken from them by a state that has no authority to be able to take those fundamental rights. So we're gonna get there, right?
We need to keep. You need to keep doing your videos. You need to keep getting the word out there, and parents, and if there's people that are in prison or anything like that, see Tanawah about the affidavit, and then as parents, we need to collectively come together and move as a one body unit, because what they're doing is it's very, very simple. It'll go into criminal court from family court if you challenge them, and you keep challenging them, and you keep putting it in there. Yeah. So they then do what you've said like previous videos. They create the monster that they said that you are because you needed to be that.
Right. And you guys understand that is what these courts do. Understand that's what these courts do. They will create an image of you. And guys, anybody that knows narcissism, think about narcissism. We're dealing with the most powerful narcissist known to mankind. Her name is Justice, and she is a bitch, guys. All right, and all of her agents are all narcissists. Every one of these judges walk around in long black flowing robes. They're hypocrites. They say that we're all law abiding, and yet they're the greatest criminals of all. Because look at how many crimes they commit every single day. Only they call it extortion. We call it theft, right? They call it treason. We call it right, or sorry, they call it misconduct. We call it treason, guys. So what they do is they build an image of you, right? And they say that you are an unfit father or you're an unfit mother, and then the court will use what's called deprivation tactics in order to make you become the exact object that they say that you are. So if they say that you're an unfit father because you don't take care of your families, then they will create deprivation tactics that will result in you not being able to get a job because they'll place 90,000 limitations on you and your ability to go and get employment. Or they'll make it so that you have to come into court every single day, and you can't keep a job, or they'll so restricted once again here. They like to restrict me, on all these, and then but when I go in after the show, and it says the restriction, and then it says the restriction's lifted every single time, you guys. So we just got restricted. You guys can't share my video once again. You can't share this live. I'm sorry if I was bullying someone or saying something there. Really apologize about that. I have this tendency of saying things that really bother people, but nonetheless. So what they do is they create an image of you, right? And then they use these tactics in order to make you become the very object that they say that you are. Okay? Now, this is a well-known, act of terrorists, but it's a well-known act of narcissists. Narcissists will create an image, and then they'll tell everybody, oh, this is what they are, right? And then eventually everybody's going to believe that, and now you're living in a world that's completely, and you're like, how is it that all these people think that I'm this way? It's because the narcissist has prepared and constructed this world of illusions around you, and now you're living in this world of illusions, wondering why is it that everybody thinks that I'm that way? It's because of the tactics that they use. And what's interesting is that these tactics, they were refined and perfected down in Guantanamo Bay, Cuba, right? Guantanamo Bay, Cuba. And you guys, my history, right? I used to work in intelligence. I know Guantanamo Bay. I know the deprivation tactics that we use very, very well. But what was happening was so the government would get some sort of arbitrary or capricious allegation that this person was a terrorist. This guy's a terrorist. We would go out and we'd find that terrorist based upon the hearsay information we got. And then we would arrest them. We'd bring them down to Guantanamo Bay, Cuba, in this facility there, Camp X-Ray, and we would put them through these horrible deprivation tactics that would mess with them physically, sexually, emotionally. And we would do it because we knew that they were a terrorist. We got information on you. We know you're a terrorist. Therefore, we're going to do these things to you until you would come in and admit that you're a terrorist. And so that's what happened. We put them through these horrible waterboarding, all these other tactics, and we would make them, we would continue to put them through it until he finally admitted what we knew that they were, you're a terrorist, and then we'd bring them in front of a single judge advocate general who would declare them guilty in the sham process known as a plea bargain down there, or a court-martial for them, but a plea bargain up here in America. But nonetheless, it's the same thing. We know that you're a criminal. We're going to arrest you on these hearsay accusations we have. We know it. We're going to put you into these institutions. We're going to deprive you of life, liberty, ability to use your property and take care of your family. We're going to do that to you, and we're going to keep you there until you admit that you're a criminal, because we know you are. And then the moment that you are willing to admit it, we're going to bring you in front of a single judge advocate general, a single state judicial officer, and we're going to declare you guilty in this sham process that bypasses the one obligation that we had in the adjudication crimes, which was a jury trial by jury. That's what's happened. So now, but what down in Guantanamo Bay, what we learned.
And so how that goes in.
What we learned down in Guantanamo
how
Bay.
That goes into the family court.
What we learned down in Guantanamo Bay is that the majority of people that were brought there weren't actually criminals, right? They weren't actually terrorists. But if you weren't a terrorist when you got there, you were when you left. So we were actually creating the very object that we were going out and fighting against in order to justify this war on terror. We were creating the terrorists by the abuse that we put them through, and the CIA knew this. Our government, DHS, knew this. We were creating, through the trauma, the very objects that we went out and fought against to justify this war on terror. And those exact same deprivation tactics are used every single day in every single jail and prison across this country, because they got perfected by our government down in Guantanamo Bay, and now they use them against the people of the United States up here in all these jails and prisons, because once they put you into that jail, these deprivation tactics that they use will make you malleable and willing to say that you're guilty because you don't want to sit there any longer. I mean, and so now they are creating the very objects that they go out and fight against in order to justify this war on crime. And that's why, you know, when we say that these people are prisoners and they deserve what they get, they deserve to be in prison, they deserve to be abused and hurt and all these other things, the problem is that that prisoner, that monster, was not born. That monster was created by the very tactics that we are employing in order to make them become that monster. And we gotta open up our eyes to this shit, because those monsters were people. They were a child, just like the children in CPP. They're all children that were hurt so that they could grow up and become the product and monster that the system gets to financially benefit from. And until we can accept that truth, we will never overcome this system. So the link between indictments and prisoners is that prisoner was once a child. And that child was ripped from his familial unit by an institution that said, we're going to be able to have long-term financial benefits from you by the things that we're doing to harm you. And so if we can accept that and acknowledge that, then I guarantee you we can overcome this system. But we can't until we start addressing the trauma of the adults, which will prevent the further trauma of the children. We must restore the familial unit. And so I'm not saying that the prisoners are good people. I'm not saying that they're lawful people. I'm not saying they're nice people, but I am saying that they're rightful people that were once a child who the government stole their rights from. And then we wonder why they become what they are. They become what they are because of the tactics that we're employing. So we can attack the preservation of the familial unit through the indictment by a grand jury. And I will be arguing on behalf of every single family in this country with that argument. But in order for me to have that argument, I have to use an enumerated constitutional right. I have to use one of the rights that's actually written in the Constitution as the mechanism to go to the Supreme Court of the United States to be heard on a direct facial constitution. De novo, which means you can't send it to a different court. The fact that I live in D.C. means there's no other court that can adjudicate this. Don't send me to a state. The fact that we've enjoined 42 states by notifying the highest judicial and executive officers in those states, those state judges, those state attorney generals, those state courts, none of them can adjudicate this because they're all recused because of the service that I provided on behalf of all of you. There's now a litigation that I can handle, and we're doing it by focusing on indictments and prisoners because they have the power to be able to save the family. They have the power to do it because their right was enumerated. The familial right is not. But we're going to change that. We're going to get there. Hey, Voices of Liberty, you want to come up, brother? You got some questions?
Yeah, hi, Tanawah. Thanks for the great work you're doing. I followed you on Facebook when you're going around serving all those attorney generals. Hey, I just want to submit something to you. Are you aware of the, little late to the conversation, are you aware of the Solicitor General memorandum that they put out removing immunity from administrative law judges? Are you aware of that, James? Have you seen that?
So that wasn't
Yeah, so that goes into like so what Tanawah was saying is, look at their actions and their words and do they align.
Yeah.
So yeah, they said that, right? They said that. Well, we'll see, I guess.
Yeah.
I just submitted some DOJ complaints against the family court judge and against my criminal court judge, and just basic violation of rights, and told them my situation. And this all goes into the Guantanamo Bay tactics. Okay, what they're doing is they're breaking down the familial unit, then they're making the stable parent into the unstable parent, targeting them. And if they still won't just do everything they say to comply, like, okay, well, then you got to go get a restraining order. Then they get a domestic violence charge. And that's how you get into the system. And then the system says, have you had enough? We're going to hold you in here. We're going to hold you in here. We're going to charge you excessive bail. And then if you get out and you want to come at us like this, telling the truth again, then you're just going to go back in there. And that's what they did to me.
Did you hear what I mentioned, Tanawah?
Yeah. So let me because that's a good question, and I a lot of people, if you guys are offended by what I'm about to say, then just understand truth is the only thing that can offend you. Okay, I'm not doing it. The energy that comes out of my mouth, this is what's going to enter into you, and it might offend you. And if it does, then I want you guys to reflect on that truth, and I want you guys to think about it. So again, words and actions. Let's go back to Chevron, right? Chevron was not the fix to the problem. All of you thought it was the fix, right? Chevron happened June 28th. You're like, oh, this is the answer, right? We got it, right? All these executive officers have to stop creating policy and going out and enforcing it. And we got the answer. It's here. It can't. But yet those were words. What happened there was that the judicial branch told the executive branch that you guys have been acting unconstitutionally, right? Because you're creating policy and you're treating it as though it's law, and you're going out and enforcing that policy as though it's law, that you don't have legislative authority to do it. So their words from the judges from the judicial branch, from the highest court in the land was, oh yeah, we know that all the executive officers are acting unlawfully, unconstitutionally. But yet there was no change to their actions because those judges still continued to come into court, still continued to prosecute people on information, still continued to permit law enforcement officers to arrest on policy. Nothing changed. Their words said, we're aware that you're criminals, but their actions said, we're going to continue to work with you criminals, right? So words and actions didn't align. Guys, they didn't align. But now, fast forward to Chevron, or to this DOJ memo from DOJ to Grassley, where they say that all of these judges they're all administrative officers, they're all hearings officers, right? They're all ALJs, and that they're going to stop protecting them from their unconstitutional acts. And so what's happening, guys, from the high level? What's happening from the high level is that Chevron was, when you're involved in a criminal conspiracy as a public official, there's only two ways to get out of it. One is you notify the authorities of the crimes, but if you are the authorities, that doesn't do any good. Or two, you must notify your co-conspirators of your intent to no longer participate, but that must be done by some affirmative action, right? And it must be documented. We must see it. If you don't see the action, there is no action. Chevron was the judicial branch pointing at the executive branch saying, we are no longer going to participate in the criminal conspiracy. All that was affirmative action that they're trying to put out and say it's the executive branch's fault. But that doesn't mean that they're changing anything, because they still continue to do it. But, right, that's what that was. That was the affirmative action. That was the first step that we needed for the judicial branch to point to the executive branch and say, you guys are acting unconstitutionally. We needed that. That was the first win that we needed. Now, the second win that we needed was, not only does the executive branch not create law, but neither does the judicial branch create law. So once we got the judicial branch pitted against the executive branch, pointing their finger at them through Chevron, well, now we needed to get the executive branch pitted against the judicial branch and pointing fingers back at them, saying, oh, no, we're not going to take the fall for this. You guys told us to do it, right? Which is what the DOJ memo is. Now, once again, words and actions. They can say all they want that they're unconstitutional, Mr. Cash and Ms. Bondi, Mr. Trump. You can say that all of the judges are unconstitutional, but when you permit your attorneys and your prosecutors and law enforcement to continue to work within that judicial proceeding with unconstitutional judges, then you yourself are committing an unconstitutional act, because you're committing the misprision of felony, misprision of treason. You haven't changed your actions despite the fact that you indicated your awareness of the criminal conduct. So the memo itself, the DOJ memo, all that was once again, that was them creating their affirmative action, pointing back at the judicial branch saying, you guys are unconstitutional, what you're doing is unconstitutional, but we're aware that you're doing that, but we're not going to change our actions, because every day those prosecutors and they're still working with these judges that they have now said are unconstitutional. But if they're unconstitutional, why are you continuing to work in that why are you still in the courtroom with them? But this is what's really going on. This is what's really going on. Okay? So those judges, right, they may very well be ALJ officers. They may very well be hearings officers. I'm not gonna argue that, right? They may very well be hearings officers. They may very well work for the executive branch. But if we accept what they're trying to feed us, because remember, government's not trying to get through this. They're trying to get out of this, right? And they're trying to get out of this by giving us a little looky-loo. They're telling us to look over here. These judges aren't judges. They all work for President Trump. They're all part of the executive branch. They're not even judges. They're ALJs and hearings officers. If we accept that narrative, right, and we accept what they're doing, the little looky-loo that they're giving us, if we accept that, Mr. Trump was given immunity on July 2nd of last year, which means that if we accept that those are his agents, he has the ability to grant immunity onto his agents, and now they aren't going to have to address these problems, because they just switched all these judges that are in a lot of trouble into executive officers, and the chief executive officer was granted immunity back at the same time as the Chevron ruling, which is exactly what they're trying to get you to do, right? They're not trying to fix this problem. They're not. And one of the reasons why is that Mr. Cash and Miss Bondi are both attorneys, and yet they're filling a law enforcement position, right? FBI is law enforcement. Attorney General is the highest law enforcement officer, and yet they're administrative officers. They should not be attorneys. They should not be administrators. They should have my degree, and they should have a degree in law enforcement. And if you're going to be a law enforcement officer, you should not have a degree that does nothing but make a person into a criminal, remove freedom. So we've got the wrong technical expertise once again in these positions, and to say that we're going to get a change in the way in which we're doing business by the same people with the same technical expertise is not true. They're focused on business and money isn't what we need to be focused on. What we need to be focused on is the restoration of rights and stop breaking of the laws. Because the money is a business, it's not the Constitution. People need the rights, and they need their rights protected by law enforcement, And until law enforcement understands its role within our system of government, then they're administrative officers that know nothing but the removal of freedom and how to proliferate their business, because that's what they're in the. If you're an attorney, you are in the business of removing the Constitution, because if the Constitution got its way, you would be out of a job. Right?
Absolutely. Can I have about 2 minutes just to share what I did? I lost my case, but I won in a little manner. And I'm not suggesting other people do this, and this is outside the family courts. But in Western Pennsylvania in Union Township, we had a bunch of tyrants there that were ignoring their oath of office and doing their shenanigans and improper quorums, passing stuff through and voting all kinds of crazy stuff. They voted themselves a $50,000 budget to hire a private investigator against me. And then they also filed protective motions, 3 law firms in the courts, to stop me from assisting my sister on her federal lawsuit. At the end of a year and a half, we removed 11 out of 12 people from office. They stepped down and resigned because of multiple attack areas. We filed actions in the executive branch. I had Christopher Hallett helping me on that, and we filed criminal investigation. It was on Bill Barr's desk, and who's another disappointment, but Maxine Waters, because she was on the oversight committee. We filed a federal lawsuit. We got discovery. We were doing paper colonoscopies, crawling up people's butts, getting all their information, humiliating them, coming in on their public meetings night, and just hammering them every 2 weeks. And so one of the reasons why I believe we were victorious was we assembled a team of people, and it's so hard to get all these liberty people to show up together, and because we're so independent in our ideas that we're not being interdependent and linking arms with other people. And like the Bundy, Ammon Bundy over there at the Baby Cyrus, the next day after they kidnapped that child over there in St. Luke's Hospital, they had 75 people out there with signs protesting the kidnapping of the child from the family services. And then they had a rolling protest where 20 cars were circling around the hospital, laying on their horns, bringing attention to the protesters holding signs. And then eventually, Ammon Bundy lost his house over a defamation case because he defaulted, and he got tired of fighting, and that guy's been battling for years against the federal government. But anyways, what are your suggestions to try to create more unity and get more people to be court observers?
Yeah, I mean,
Thank you.
Hey James, can you put it on mute for a moment? Yeah. All right. So, I don't know. Bringing unity has been my challenge all along here. Hey James, can I put it on mute? Thank you. Okay. So unity is the biggest challenge. Again, Alexander the Great, he had this philosophy that an army of lions and bears led by a sheep will be defeated by an army of sheep led by a lion. So, I consider that quite often, because these prosecutors and judges are lions and bears. They're tough, right? We don't want to fight them directly because they'll obliterate us. They're a superior fighting force. But if their leadership is a sheep, if the Supreme Court of the United States is a sheep, which they are, they're criminals, right? Then we can take down their leadership, and in taking down their leadership, the whole army will fall, because an army has no power without their leadership. So, but we can take that a step further, because how does a lion hunt? If a prosecutor's a lion, how does that lion hunt? Well, it jumps in the middle of the herd, and it gets one sheep off by itself, fighting by itself. Because as a herd, they can't stop them. If the sheep all stayed together in a herd, those lions would not be able to take any of them down, because they have to have them off by themselves to take him down. The lions can't do it in the group, but they can do it individually. This is what the prosecutors do. This is their plot. This is their lion mentality. They will jump in the middle of the group, and they'll get you off over here arguing your own issue. Like, oh no, defending yourself, right? Because they want you defending yourself. They want you to say, oh, the biasness of the judge and the lies of the prosecutor and the irregularities in the evidentiary procedure. All of that, they want to get you off arguing that, because by yourself you have no power. as a group, we have all the power in the world. Because if the whole group had rights that were fundamental, protected and preserved by the Constitution, then all of the whole group could talk about the one issue. If jurisdiction is that one issue, if that's the first point, the arrest, state doesn't have the authority to detain you if the state itself is bringing an accusation against you. That affects everyone that's been arrested and charged with a crime. If the state doesn't have the authority to take your child, then all you need to talk about is that issue. State, you can't take my child because the Constitution protects my relationship with my child. Nothing else needs to be said. But they want to get you off. They want to get you over here talking about what CPS did, or over here talking about what law enforcement did. They want you over here talking about how biased your judge is, because all of that takes you into an area of arbitration that they can now arbitrate. But if there's nothing to arbitrate because you're on offense saying, state, you couldn't take my kid anyway. You couldn't take my kid to begin with. If you talk about that issue and nothing else, now there's nothing to arbitrate, and now you're on offense telling them, address your crime. You committed a crime when you did something that the Constitution said you couldn't do, and we don't talk about anything else. Now we get a massive number of people talking about one single issue, and if we get 10 million people talking about the fact that the states don't have jurisdiction to be able to address this issue because the state itself is a party, then by doing that, we now reduce the noise level, and we now stay together as a herd, to where the lions can't break us up and send us off to do whatever. But I'm going to take it one step further, even further, right? Because Alexander Great said, an army of lions and bears led by a sheep will be defeated by an army of sheep led by a lion. Guys, I'm your lion, all right? I'm your leadership. I built this case. I'm ready to take it down because their leadership is a sheep. And I'm going after that Supreme Court. And if I go after it, then the way that I have to fight is the same way that they fight. Remember, those lions jump in the middle of your herd, and they get you off by yourself, fighting by yourself, because they can take you down one at a time. All these courts, everything is all built to protect the Supreme Court of the United States. They are there as the protection of that sheep. Because I'm jumping in the middle of their herd. That's why I'm out here serving these AGs. That's why I'm out here serving Supreme Courts, is because I am jumping in the middle of their herd to try to draw that sheep out by itself. And as the moment I can get that sheep off by itself, defending itself, I'm going to take it down. And when I take it down, their whole army will fall. So I'm simply using the same strategy that they use on you by jumping in the middle of their herd, because my whole intention is I want that Supreme Court of the United States, I want it drawn away. And when I draw it away and make it defend itself, that's when I'm going to take it down, because it's a sheep. And I can take down the sheep. I don't have to fight their whole army. All I can do is fight the sheep. I can take down the sheep. Once I do, it's done. So that's what we got to do. Use their same strategy. Jump in the middle of their herd, cause chaos among them, right? And once we do, the whole point is we want to draw that sheep away. We want it to start defending itself, because the moment that the sheep is defending itself, we the people will take it the fuck down. And you guys can allow me to do that. You guys can give me, but I can't do it on my own. I need you guys to push me there. Therefore, it's going to be all of us together, but we got to do it together. That's what we have to do it together. That's why I say that we've got to stop defending ourselves, and we got to go on offense. You go on offense by accusing them of the crimes that they've committed against you, and you stop talking about anything that they're accusing you of, because there's nothing to talk about. Because before you have to talk about any of that, they had to have the authority to do it, and they didn't have the authority to do it.
Absolutely, yeah. And I love the offensive strategy. Like, I try to at least go into two branches of government in every cause of action. In fact, you could do the three. The criminal complaints you could file, go to the state legislators, petitions, remonstrances through the Congress. And I stopped AB 957 out here in California, which was a transgender affirmation, through a remonstrance. And when Governor Newsom vetoed it, he vetoed the bill because he said it wouldn't survive the federal courts. And within the remonstrance, I had the federal lawsuit that I was going to file against California. And apparently he decided to veto the bill, which we know he stands for the transgender thing. But I like the offensive strategy. Like I said, if we can hit all three branches at the same time, so these judicial, imposters realize, well, I got executive branch members looking at this stuff. I got, the legislative branch looking at me, and plus we're showing up in masses. So yeah, thank you for working so hard. Love what you're doing.
Yeah, and so the Sun Tzu said in the book The Art of War, he said that the first step to reach victory is you got to break up the alliance and pit them against each other, right? So you got to break up the alliance. But we have three branches. We have two branches that are in direct collusion with one another: the judicial and the prosecutorial, the judicial and the executive. So the prosecutors and judges are in direct collusion. Those two branches of government are in direct collusion. So the only way that we can address this is by getting the attention of the third branch of government to provide new oversight, and through that new oversight, we can address the action. These branches of governments will correct their behavior, because if they don't, they're all implicated in it. And it took me a long time to get the legislative branch incorporated in. I did that through the 14th Amendment's the final clause, or the final provision, where it says that Congress shall have the power to enforce this article. So any violation of the 14th Amendment, enforcement transfers from the executive branch into the legislative branch, and now the legislative branch is constitutionally obligated to enforce a violation of the 14th Amendment. So we're able to incorporate the legislative branch when they say, oh, we abstain, we don't get involved in this. That's just them saying we're too big of cowards and pussies to do something about this because this too big of a deal. We don't want to get involved. But we can make them be involved, because guess what? When a state creates a law that abridges a constitutional obligation, right, then you have the duty to enforce it, because enforcement is transferred onto the legislative branch. Congress of the United States, you don't have the ability to abstain in this because you have a constitutional obligation to address this, right? And so that's what they have to do. Am I a bar member? I'm not a bar member. I will not swear allegiance to the bar. So, the bar is the problem. I'm opposite, guys. So, no, I'm not a bar member. I'm an advocate.
May I chime in real quick?
Yeah, Crystal, hey.
Okay. Hey, so I can explain my story here in a minute. But one thing that I wanted to ask you is, what about the False Claims Act? I've been looking into that, and me having a CPS case, I feel like a lot of us parents have a good claim for the False Claims Act, and to my understanding, how it allows a private citizen to sue, if you will, on behalf of the U.S.
So that's that. I am stepping up as a private attorney general, right? I haven't been authorized with that authority yet, but I'm absolutely qualified to do it. I have the oath that's already required to do it, and so no. But the other thing is that what you're talking about is an area of arbitration, and I want people to get away from the area of arbitration, because again, if we can talk about, if we can find a crime, any crime, if we can find a crime that government committed somewhere in the process, then the moment that crime is committed, everything after that is automatically unconstitutional. So we don't want to talk about things that are within the area that can be arbitrated. So what you're talking about is false claims. You're talking about how the judge introduced fraudulent evidence, or the prosecutor introduced fraudulent evidence, or they refrained from permitting evidence to be brought in, regardless of what it is, or the particular scenario. Long before that issue came up is the issue of, did the state have the authority to take your children, Crystal? And they didn't. Right? They didn't have the authority to do it. That's where we want to talk about, because the question, does the state have the authority to abridge a fundamental constitutional right? The answer is no. So if the fundamental constitutional right is you have a right to have an intimate familial relation with your children without governmental interference, that is the right. That's the fundamental right. So that's what we should be talking about, because the moment that they took your children, regardless of why, they committed an unconstitutional act. But they want to have you looking over here, right? They want to bring you into something else. They want to say, oh yeah, but we're going to introduce all these lies, because by introducing these lies, now you are going to be offended by those lies, and you're going to argue with them. Fuck your lies. I don't give a shit. Because long before you can introduce those lies, you didn't have the authority to do it. And so, you know, I want everybody to step back, stop giving them something to arbitrate, stop talking about the things, because remember, just like the scenario, the army of lions and bears, the lion is going to jump in the middle of the herd, and they're going to get you over here talking about the Fair Claims Act, right? They're going to get you over here talking about the lies that were introduced in the proceeding. And if we all step back and say, no, we're going to remain together as a herd, and the herd is going to say one thing: Supreme Court of the United States, you had an obligation, why didn't you do it, right? Supreme Court of the United States, why is it that states are doing something that they cannot constitutionally do? Because you have the obligation to do it. Every one of us, every mother that has had their children taken, every father that's had their children taken, all grandmas and grandpas, aunts, uncles, brothers, sisters, cousins, friends, family, all of them that have had their familial unit destroyed, we can ask the question, government, why did you interfere with this familial unit? Why did you do it? And likewise, everybody that has been detained and had their liberty taken from them without lawful authority because the state brought an accusation against you through one of its agents, all we got to do is point to the fact that, state, why did you do something that you couldn't do? And when we do that, when we talk about that one issue, we get magnification on that issue. Because right now, today, there's 70 million people that have been charged with or convicted of a crime by the justice system that no one that didn't have the authority to be able to do it, because these states didn't understand the laws. All of them could talk about the same issue, which means that we as a herd can come together, remain together, talking about one thing, moving forward on opposition or an offense, accusing them of the crimes that they committed, and don't break off. Don't let them bring you over here defending yourself, because we're no longer defending ourselves. We're going on offense and we're going to score. So, yeah, but your issue. Your issue,
yeah, that makes sense.
Your issue is going to be important when it comes to injunctive relief, right? Everyone has a story, and you're all going to tell your story. I promise you, every one of you will have your opportunity to tell a story, but there's a time and a place. Right now is not the time to tell the story individually. Right now is the time to tell a story collectively. What has government done to us? What has the government robbed from us? And when we do that, then we're going to win, because there is no right to self-defense for a public official. You can never justify an unconstitutional act, because an unconstitutional act can never become constitutional. So once we identify a breach of constitutional obligation, we stick with that, because there is no right to self-defense for any public official to defend their breach of constitutional obligation. None. So we go on offense at the moment of jurisdiction. We say, states, you didn't have the authority to do it. Courts, you didn't have the authority to do it. Judge, you were not a judge, because that court was not a court, because jurisdiction is what creates the court. The court's what creates you. You are nothing. You're a person pretending to be a judicial officer, which brings me back to what we said with you, Voices of Liberty. So this is the thing with these ALJs and with this DOJ memo. If you guys buy into the looky-loo, and you accept the fact that these are just ALJ officers that work for the president, so on, right? They can grant immunity onto those agents. Trump can, and as a result of granting immunity onto them, whatever they've done can be valid, right? Don't fall in this trap. Don't let this trap play out, right? Because that's what they're trying to do. They're trying to find a way out of this, not through it, all right? But here's the thing, okay? So I use the analogy of a water gun. That's my favorite one to use, because if we're walking down the street, and I walk up to you with a water gun, and I say to you, give me your money or I'm going to unalive you, right? If you give me your money because you believe that that water gun is a real gun, and I portray it as a real gun, it's a gun, right? It may be a water gun, and it may not be able to do anything to you, but if you believe that it was real, it's real. And as a result, when you walked into that courtroom, did you believe that ALJ was an ALJ, or did you believe that was a judge acting under judicial authority, and the decisions and action that they make is valid? No, you thought it was a judge. So don't accept what they say by the looky-loo saying, oh, it's just an ALJ officer. No, that was a judge. I walked into there, you portrayed it as a judge, right? They portrayed themselves as a judge. I believe that they were judge. Therefore, the contract that I entered into because of my fear and duress that was inflicted by someone pretending to be a judge is still a judge. And it still is, and that's the way that you're going to be able to fight this. If you guys attempt to accept the DOJ memo and what they're trying to portray the DOJ memo as, then they can get out of this, because they can grant them immunity on those agents. But that was not an ALJ when you walked in that courtroom. they portrayed themselves as a judge. Do not accept what the narrative that they're trying to give you. That was a judge.
Maxims of law support what you're saying. Even if somebody is de facto, operating de facto, they will be treated as de jure, you know, for what you're saying. So there's definitely a maxim backing that up. I love that.
Which is why also why my affidavits, you guys, I didn't ask for the name of the judge. I didn't ask for the name of the prosecutor, because we don't want them in their official capacity, because their official capacity doesn't exist. That was a person portraying themselves as a judicial officer, just like it says in the affidavit. There was a person portraying themselves as a judicial officer in that room. Now, whether they were a judicial officer or not, that would be where the name would come in. I don't want their name. I want the affidavit says a person portraying themselves as a prosecuting attorney, because they weren't a prosecuting attorney. But if you use the name and the individual in the individual position, then yes. But there was a person in that room pretending to be a prosecuting attorney. And then the next part.
Yes, always sue them in their private capacity, always.
Right. So that's what we're doing. We're identifying them in their private capacity, because that was not a judge. It was not an ALJ, because neither of which had the authority to exist absent the constitutional jurisdiction that was statutorily imposed upon them. And if jurisdiction
and your
doesn't
affidavit
exist,
sets them up for deliberate indifference, which causes them to lose their immunity.
Yeah. So guys, I gotta go here. It's 12:30 and I'm a half hour late getting out of this hotel, and we got a couple things to do. So say a prayer for us today, please, because we've got another exciting day that we're gonna try our best to make something happen. But guys, we got the first domino about to fall here, and Mr. Stitt, I just suggest that you wake up, pull your head out of your ass, because you're gonna be the first bankrupt state. You're gonna be the first one. Crystal, we'll be in touch later. Sorry that I didn't get you up and talking much here.
Oh, no worries.
Okay, thank you guys.
Yeah, it was definitely technical difficulty.
Thank you so much, Absolutely. Thank you guys so much. Please continue to like, follow, share. If you guys can, please donate. We do have Cash App, Chime, Venmo, PayPal. They're all exactly the same. I do this for free, you guys, because you guys need this help. And all these people that are in prison, they don't have the money to be able to do it. These families don't have the money to be able to support. So just understand, if you guys do donate, you guys are donating on behalf of someone that doesn't have the money to do it. We're going to continue to do this. We're going to get this done. Love you guys so much, and together we shall be free, all right? Thank you guys so much for participating. Thank you. Thank you, YouTube. Thank you so much, all right? God bless. We'll be in touch. Thanks, guys. Thank you over here.